All right. Thank you, everybody, for joining us for our Monday Zoom and Learn. My name is Tommy Dutcher. I am the Area Sales Manager for California Title. And we have a returning guest speaker today, Andrea Shoup with Shoup Legal. And Andrea is going to be walking us through the probate process this time, the basic elements of a probate, when you do or do not need a probate, the distinct differences between, things in a listing and selling of a probate property, etc. So I hope everybody is ready to take good notes because I'm sure you're going to learn something on this one. On the other side of my duo is Tracy Hassey with Granite Escrow. Tracy, do you want to introduce yourself and your team?
Absolutely. Hey, good morning, good afternoon, everybody. We're so excited to be here today. And once, as I was saying, as we were speaking earlier, so great to have Andrea Shoup here today. She's a wealth of knowledge, and you're all going to take away some great nuggets of wisdom. And our team is throughout Southern California. We have 8 offices, so we probably have guests. Want to welcome our guests from all the different offices, and those of you that are listening to the replay. So welcome, welcome. And let's get started.
Yeah, so Andrea, I will pass it over to you. If you could give your brief introduction of who you are, what you do, a little bit about your background, and then I've given you the ability to share, and we look forward to what you have to share with us today.
Yep, absolutely. Perfect. Thank you. All right, so I'm going to share my screen, and ideally that worked.
Yes.
Okay, perfect. And just make sure and I've been talking with people, so I know you guys can hear me, so I just want to make sure.
Yeah, your volume is a little bit in and out, so I think you need to be like right in front of your screen.
Perfect. Okay, good to know. Thank you. All right, and so really I'll talk a little bit.
Before you get started, I just want to mention Mary Jane Morris is going to try to get on the call. She's usually the standard host here out of our Temecula Riverside region. So she just apologizes for not being able to be here right now. So just wanted to acknowledge her, and because she is our main host, and I'm grateful to be, kind of subbing on her behalf. So take it away.
Awesome. And I'll also say, if anybody has any questions, let me know. I found that I can't really monitor chat while I'm talking and doing the presentation. So if you type a question into the chat or question and answer or whatever, just know I'll check that at the end, but I kind of can't do them both at the same time. But if you do have any questions, go ahead and let me know. So a few things that you're going to learn today is what to do if your client becomes incapacitated, what happens if a property owner dies, and how to use a trust to avoid probate and the probate process. And really, this is for you if you advise clients who own real property in California, you're confused about the probate court, kind of what is it and what you need to know about it. If you don't know what to do if someone like your client becomes incapacitated, if you're not sure what a trust is and you want to provide additional value to your clients. And at the end of the presentation today, I'm going to share with you how you can have the opportunity to sit down with a member of our legal team, ask your specific questions, and really get additional training, personalized training, so you can best help your clients. So as an introduction, who am I? I am an estate planning attorney, and in fact, I'm a certified specialist in estate planning, trust, and probate law. And before I did that, I actually spent nearly 6 years in the district attorney's office, and I was a felony trial prosecutor. And during that time, I was expecting my first son. And when that happened, all the what ifs in life started playing, right? What if my husband didn't come back from that deployment? What if something happened to me? What do we do with our little boy, Matthew? How do we plan for him? How do we protect him? And as I started learning about what we needed to do to protect ourselves, to plan for ourselves, I really saw how important it is and how bad it can be for families when they haven't planned. And I was terrified of my son going into foster care because we didn't have something in place. And even if it was only for 2 weeks, trying to get a judge to, have my baby go with my parents. It was 2 weeks too much. I really understood and saw the importance of families planning for themselves and making sure that families protected. And now that I have 4 little ones, I am still passionate as ever in making sure that families have the information that they need and the understanding of what they need to do to protect themselves. Because really, if 2020 taught us anything, it really is that the unexpected can happen at any time, right? And so we've got to make sure that we plan and prepare for ourselves. So the first thing we're going to talk about is what to do when your client is incapacitated. When I say incapacitated, what do I really mean? I mean that they're unable to manage their financial affairs. Maybe it's because of an illness, maybe it's because they suffered a coma, a car accident, any number of things, but they're not able to manage either their financial affairs or their personal affairs, making sure they have shelter, clothing, clean clothing, food, and so forth. So if that happens, we need someone else to step in for them. And a very common way is by using something called a power of attorney. Now, powers of attorney can be wonderful, but they are not all the same, okay? Not all powers of attorney are the same. Some of them are very specific for only certain situations. Some of them are very broad. It's very important how exactly the power of attorney is drafted and what's included in the powers, right? Power of attorney powers, what powers are granted. Because if they're not the right powers, then it's not going to work. I actually had a situation several months ago. A notary had suggested that a family use just a form power of attorney, and he probably found it online somewhere, because the family wanted to sell the house. Unfortunately, that form power of attorney did not give the ability to sell the family home. What could they do? Unfortunately, they couldn't do anything, because by the time they figured that out, because they went to a title company that said, I'm sorry, this power of attorney doesn't work, it was too late, and the dad had already declined too much, and they could not have a new power of attorney signed. So you've got to be really careful when you're talking with family about if they're going to use a power of attorney, that they have the right one, not just something that they find online, because not all powers of attorney are the same.
And Andrea, pardon me, I'm just going to say something is,
Please.
I get this question a lot from real estate agents, and a lot don't understand that the power of attorney dies with the individual that the power of attorney is for. And a lot of times they're like, oh, we have a power of attorney, but the person that it's for, has now passed away.
Yep. Yeah, that's absolutely right. Because the power of attorney really it's only valid during their lifetime. You're exactly right, Tommy. And let's say that happens, Tom. Like a family comes in, they have the power of attorney, mom or dad, they just passed away. Can you still issue title insurance on that? Can we still close escrow?
In most scenarios, no.
Yeah. Yeah,
and they don't understand that it's great while somebody's still alive and they're not able to act on their own behalf, or they're not here, they're deployed, or they may be sick or not in the right state of mind or what have you. It's one thing when they're still physically here. It's another when they've passed away and now they're trying to make decisions of like selling an estate or what have you. And most do not understand that the power of that attorney, the power of attorney died with the individual.
Right, exactly. And it's also, it's important to know that the vesting matters, okay? You've got to know, especially when you're working with an incapacitated owner, you've got to know who's on title. How do they really hold title? Because you have to understand, are they incapacitated and now you need the power of attorney? Maybe they're incapacitated and there's a trust. Maybe there's somebody else on title. Please, please, please pull title early, pull it often. And you have an amazing title rep here who, he must care about you, because they've arranged to have, me come in and talk with you and provide valuable information to you. So you know that they're here to help you. So, reach out to Tommy, make sure you pull title early, pull title often, make sure that you understand who's on title and how they hold title. You got to do that early in the process. Don't wait till the end. Don't wait until you're about to close or whatever. And don't even wait until you're in escrow. Do it way beforehand so you have a good understanding of the players and who you need to be talking with. Another question I'm often asked is, well, should I just add someone to title? That'll be easy, right? Please don't don't advise a client to do that, and please don't help them to do that. There are so many pitfalls with this. It is unbelievable. One, they just gave someone a gift, a pretty substantial gift of maybe half their home. Now they will likely need a gift tax return. That's something that's often missed and not done, but that's a very important part of it. Also, the idea of a gift is just that. It's a gift. You have given it away. It's not something you can give away and take right back. It's something that's gone and you lose control of the property. Also, a lot of times, capital gains tax just got messed up the moment that gift was given. And that can cost hundreds of thousands of dollars in taxes. I had a situation where a gentleman was dying and he wanted his house to go to his sister. He had no children and all his other siblings had already passed. So he wanted to give the gift to his sister, added her to title. And unfortunately, he did that 6 weeks before his passing. That small thing actually resulted in her paying about $95,000 in capital gains tax when that property got sold, because he gifted 6 weeks before death. If she would have received it on death, there would have been no capital gains, because the capital gains tax, it just got messed up by giving the gift early. It can increase property taxes now because of Prop 19. There are, whenever there's a transfer of property now, it can trigger a reassessment for those property taxes. So you've got to make sure that explain it, but tell people don't do this. Don't just add someone to title, because it can trigger a property reassessment now, meaning they will forever pay higher property taxes on that property. And the property was just opened up to the person who's receiving the gift, to their creditors, to any of their liabilities. Let's say they get divorced. Well, now guess what? Half of that house is now available to that spouse, that divorcing spouse. Most people are like, wait, what are you talking about? No, it's still my house, right? No, you gave half of it away, and now a divorcing spouse might be able to come in and take part of that. What about a dog bite? It's very interesting. This happens more often than you think. I had a client who husband and wife, they added their son to title to, help with, estate planning. And their son's dog actually bit someone. Well, son didn't own a house. He lived in an apartment. The owner of the dog came back after husband and wife and their house for that dog bite. And that it's not an isolated event. I know of like 3 people that's happened to, and that's been just in the last few years. It happens. Also, that idea of loss of control. Now, let's say, someone is added to title because someone's sick, and we're like, that doesn't look good. Maybe they're not going to recover, but they do recover. They don't get to just take their property back. It's not automatic. You can't just change your mind. Tommy, let's say I gave half of my house to someone, to Sally, right? And now I'm all better. Can I just take that back from her? Can I just sign something and say, just kidding, I didn't mean that?
Oh, Sally would have to be the one that does it and signs it back to you.
Now let's say I want to sell my house, right? And Sally, maybe someone's like, okay, go ahead, you can sell your house. Who does that check get made out to? I mean, it's my house, right? That the proceeds for the selling of the house, it just comes to me, right?
Yep, goes to both of you now.
Because Sally owns half of it. There's so many things that people don't realize when you add someone to title. Please, please, please please, 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 please don't help your clients and don't advise your clients to just add someone to title. There are so many unintended results that cause some really, really awful results. So you've got to get them to an attorney. Most of the time, you can have a very quick turnaround to get something done. I'll say my office has routinely been able to turn around an estate plan, a proper estate plan, within 24 hours. When you get them to an attorney, they can have solutions that solve many concerns, right? It's not just one little one. It's all of the concerns that I just talked about: property taxes, capital gains taxes, creditor issues, loss of control, all of that. You've got to, if you're advising clients and you care about clients, you've got to have them do it the right way. Don't let them fall victim to, well, my neighbor said if I just put so-and-so on title, I can avoid probate. Well, okay, but it opens them up to so many other things that they should not just do that. And also, I think of Purple Bricks. Remember, I mean, I know that they're now defunct, but people were trying to save money, right, with Purple Bricks, and it just created so many issues, and it was awful for the consumer. I mean, it was awful all around, but it was awful for the consumer ultimately, and that's why it shut down. Saving a little bit of money is not the way to do it when so much is at stake, such as someone's home. That is the biggest investment that they make, usually in their lifetime. We've got to help them protect it the right way. So get them to an attorney. What happens when a property owner dies? So we talked about what happens when a property owner becomes incapacitated. What happens when they pass away? Well, it depends regarding how they pull title. That's why, as I said, pull title early, pull it often, know who you're working with. So depending on how the property is held, let's say the property is held in a trust. It actually is pretty simple. Let's say Fred owns his property, Fred as trustee of Fred's trust. Fred passes away, the trust will say who the successor trustee is. And it happens to be, Barney. And so now Barney is a successor trustee. Something gets completed, it's an affidavit change of trustee, it gets recorded, and now Barney is the new trustee of the trust, and he can transact property on behalf of the trust. It becomes very simple and very easy, but you've got to make sure that you know how title is held and that it is in a trust. What happens if it's held in joint tenancy? Joint tenancy is when it's two or more people, and it could be any number of people who own property, but it has to say those words: as joint tenants, in joint tenancy. Those are magic words that it must say. And when it does, the great thing is it has an automatic right of survivorship. What does that mean? It means that if Fred and Barney owned property together, if Fred passed away, the moment he passes, the moment he dies, Barney is the 100% owner, okay? And it makes it very simple. However, the only thing is you have to complete and then record an affidavit death of joint tenants and also record the death certificate that shows that Fred in fact did pass away. But it becomes fairly simple when there's joint tenants, right? As long as Barney's still alive. We'll talk about it if Barney's the last man standing and then he passes. All right, so what happens if we have tenants in common? So property that is held as tenants in common, this is a default. This is what happens when nothing else is said on the deed. Okay, let's say it just says Fred and Barney. That's it. Nothing more. It doesn't say joint tenancy or anything else. The default is it defaults to tenants in common. So tenants in common does not have an automatic succession. There is no right of survivorship, no automatic succession. So if Fred passed away, it does not pass out of Fred's estate. It doesn't go to Barney. It stays in Fred's estate because there's no automatic succession. So you have to be really careful. And again, this is the default when there's nothing else said, and sometimes it does specify tenants in common.
And,
if that happens,
and we get this a lot from the title side of business. And a lot of times, you know, you have husband and wife and a son, say, right? I had this just literally last week. Husband and wife and a son. The wife passes away. The husband is still alive. The son is still alive. They decide they want to sell the house and dad's going to move in with the son. House is not in a trust. And so the wife's portion of the estate has to go through probate.
Yep. Because it probably didn't say joint tenancy or anything else, so there's no automatic succession. And that's when you need a probate court order. Now, Tom, you know, if your title officer is saying you need a probate court order, can you like somehow skirt around that? Is there any way, like, you can't get around that, right?
No. Underwriters on the title side of the business and the insurance side of the business, underwriters will look at this and say, without a court order, we won't issue a title policy. Right. So therefore, you're kind of at a standstill. And it's funny because I've seen people where this has happened and they've still sold the house as cash without a title policy to somebody, and that person had no idea, and they gave them hundreds of thousands of dollars. And then years down the road, they decided that they wanted to sell it. The title's still clouded from this happening. Yep. And, you know, it makes things really, really difficult. And so, you know, there's really no way of skirting around it. You know, it sometimes helps if it was, say, a husband and wife or something like that, and you have the ability of proving your relationship and all your next of kins and all that, and it's not a full-blown probate, and you could probably get it pushed through the courts fairly quickly in normal terms, right? In normal day and age, but you still have to get the courts involved.
Yep. What if I'm the only son? No one else is going to get involved. Can we just skirt around it that way?
Nope. You're still going through the probate code process, you know. And
what if they have their
that comes up so often as people go, oh, I don't need a trust. We only have one kid. Everything goes to him. Well, guess what? Trying to explain to somebody who is, say, in their 60s or 70s that, yes, you only have one child. There's nobody else that any of your stuff can go to. However, anything classified as real property of substantial value, guess what? Your son or your daughter, if they're the only ones there, are not going to be able to transfer that property into their name. They're not going to be able to transfer that car necessarily in your name. They're not going to be able to do bank account stuff into their name. All this stuff that plays a part still belongs to the probate code.
What if I have their will? Like I have dad's will and dad says it goes all to me. Is that enough?
No,
you still need a probate court order.
It definitely helps with a length of time of that probate, right? But it's still going to go through probate.
What if I was dad's power of attorney and dad's passed away?
Yeah, the power of attorney died with dad, and you're still in the same predicament as if you didn't have a power of attorney.
Yep. Unfortunately, when a probate court order is needed, there's no way to get around it.
Right.
And that's, you know, and then also, you know, if the property is titled in someone's individual name, and now, you know, remember it was Barney was last man standing, and Barney's now passed away. There's no one left to sign the deed, right? Mm-hmm. There's nothing else we can do. We need a probate court order. So let us start talking about probate. What the heck is it? What does it mean? And let's say that's something my client needs to go through. What are we doing? I've found most people kind of sort of know what probate is, but they're not really completely sure, but they know they don't want it, right? So what is it? It's a court process. It is the procedure of transferring assets from one person to someone else after that person's passed away. It is a fairly lengthy process. On average, I would say most probates take about 2 years to complete, give or take. It is a very public process. Everything is filed in open court. Everything that we think of as maybe fairly private information, such as our banking information, our bank account numbers, our bank account balances, it's all public record, all filed in court. It's also a very costly process. I would say on average, well, let's say probate fees are determined based on the gross estate value. And that means basically it's fair market value of the house, and we don't look at the mortgage, right? So if the fair market value of the house is $500,000 and there's a $400,000 mortgage, fair market value is still $500,000. Okay, we don't look at the mortgage. And probate fees are a percentage of the gross estate value. So think of a fairly modest estate of $500,000. Probate fees exceed $26,000. And that's just for the sheer honor and privilege of going through that probate process that nobody wants. That is why we try to avoid probate, right? That's what we want to avoid, is paying fees like this. And a probate court order is needed when we have any real property of any value. It could be a multi-million-dollar estate. It could be a small little lot in the Salton Sea. Any real property will need a probate court order, okay? Or if we have assets over $166,250,000. If either of those are true, if either of those situations have occurred, we have to go to probate court, and there's no way around it. When probate is needed, there really is no way to avoid it. So let's talk more about the probate process. So essentially, the probate process starts with the filing of initial probate petition. It's a petition for probate. You're knocking on the court's door and you say, "Judge, I need to open this probate. Can you let me?" It takes about 45 to 60 days to get our initial hearing. At that initial hearing, ideally, the court will grant the petition. If letters are granted, usually we'll get those letters about 2 weeks after that hearing, by the time we get the certified copy. And that's because right now it's difficult to get into the courthouse to get certified copies of anything. It's all done by mail. So sometimes this actually takes a little bit longer. So after, and those letters being granted, that's authority. That's giving somebody the ability to do something, that executor, the ability to operate on behalf of the estate, okay? So about 4 months after letters are granted, that's when an inventory and appraisal is due. That has to be filed with the court. And that's that inventory. Remember, I talked about all the stuff, the private information, banking information, our real property, our bank balances, our brokerage account balances, all that fun stuff. That all goes on an inventory, and it gets appraised by a probate referee. A probate referee is a court-appointed appraiser, okay? And about 1 to 2 years after that, that's when the final accounting and petition for final distribution is filed. And again, that's about 45 to 60 days before we get our hearing or on that final distribution, and about 10 more days to get an order actually granted and received so we can distribute. That's a really brief overview of the entire process, but the part that you're most concerned about is when you can list the property. And you can list it about 60 to 75 days after we start the probate. It's when the letters get granted, okay? Please wait until letters are granted before you list the property. I have seen so many situations where we're very eager to list the property, you know, generate excitement about it, make it the property people want. Please don't do that until you know your client has the court authority to sell the property. Before then, you're just kind of, you're inviting trouble, you know, you're inviting Murphy's Law to have something come up. Have the court not grant it for any reason. I actually had a situation where we had a tenant in the property who everybody said, "Oh, they're fine, they're great, of course they'll get out." Well, they didn't, and we had to now evict the person. Unfortunately, the agent, the real estate agent, was was the one who thought, "Oh yeah, she'll be fine, she'll get out." They listed the property. They tried to have open houses. The tenant made it would not let the open house come like actually happen. So the agents there like not able to get into the house. Other agents are coming by with their people. It was a mess. It was awful. The property actually sold for less because it became like the tainted property. So please, please, please wait to list the property. All right, so some common probate terms. One is executor, personal representative, administrator. For all intents and purposes, they mean the same thing. Okay, we're kind of familiar with the term executor, right? We've heard that, executor of the will. It's the person who's in charge of the probate. That's the person with the authority to act from the court. It's the person who's been deemed the one with authority. A lot of times it's called the administrator, or just a blanket term would be the personal representative. Again, for your purposes, they all basically mean the same thing. Probate referee, as I mentioned, that is the court-appointed appraiser. All property must be appraised, and like all real property has to be appraised by the probate referee. An heir is somebody's natural heir. As I mentioned, I have 4 kids. They are my natural heirs. The difference between an heir and a beneficiary is, let's say I love the spotted owls and I just want to save the spotted owls. So I decided not to give any of my property to my kids who are my heirs. And I then choose to save the spotted owls with my money. So the association of saving the spotted owls becomes my beneficiary. It's somebody I select for myself. Now, a lot of times it could be the same person. It doesn't have to be different, but a lot of times, but there is a distinction between heir and beneficiary. Letters of administration, letters testamentary, this is the court authority. This is the court authority to act on behalf of this estate. You want to be talking to the person who has the letters, who has the authority from the court. Sometimes, you know, I've talked to agents and they're like, oh, son's this, son said this, we're doing that. And I'm like, well, who's the personal administrator? I don't know, I think it's son. Well, ask to see the letters of administration, and it ends up being somebody completely different. So you got to make sure that you're talking to the right person. So I want to talk about the 2 different types of probates. When you're going through probate, somebody can either have full authority or limited authority. When somebody has full authority, unless they decide otherwise, no court confirmation is required to sell real property. And this can be very similar to a normal listing. You do have to use the probate addendum. There's a special addendum for probate listings, so you've got to use the proper addendums. And you still need a probate referee to appraise the property. Okay, that all must still occur, but it can be very similar to a normal listing, and you don't need court confirmation many times. Sometimes the attorney might decide to seek court confirmation, or something else might happen where they end up needing it. But when somebody has full authority, it can be very similar to a normal listing. Sometimes we have limited authority, as I like to call it, no authority. It's not completely accurate, but that's how it feels when you're selling property. And that's when court confirmation of the sale is required. That's when we have to have the court confirm the sale. And this is very different from the normal listing process. You still have to use the probate addendum with your normal listing agreement, and the appraisal by the probate referee is still needed. But there's some other limitations as well, including that court confirmation process. When you, the notice of the sale must be published in a local newspaper. It has to also be posted at the courthouse. And then there is an in-person hearing where the judge basically can auction off the property if there are any overbidders. So an overbidding situation could come into play. A few more challenges with listing property in probate is many times there's little access to funds for repairs and costs and so forth. Improvements versus repairs might not be reimbursed by the court depending on if anybody's challenging it. So you've got to be careful with what you're suggesting to the client as far as improvements before they list the property. The personal representative has to adhere to court standards for making decisions, including it to make repairs or not. Usually there's no help for cleanouts, junk removal, and so forth. But most importantly, you've got to remember you're dealing with a grieving family. So you've got to make sure you remind yourself of who you're working with and the emotional state that your client likely is in. It's very difficult for people to be selling mom or dad's house, especially if maybe it's a childhood home, many memories there. It's a very difficult process, especially if they just lost mom or dad. So you've got to be flexible. I would say make sure you expect the unexpected. Anything can happen in probate listings. I have had some crazy things occur, but they just come up and you navigate around it. My suggestion, work closely with the probate attorney. Okay, become friends with the probate attorney. Call them up, introduce yourself, and remember, you guys are on the same page. Most attorneys, they want the same thing you do. Sell the house for the highest amount in the shortest amount of time possible, right? Let's make it a straightforward, simple transaction. Let's communicate, get each other the information we need, and be done with it. Close it and go on to the next. So please work closely with the probate attorney, make friends with them, and make sure you guys are on the same page.
Hey,
Yeah.
I am watching the webinar on probates.
Please put yourself on mute, Mark. Thank you.
Okay.
And
So
getting a lot of interesting information.
I'll take care of it.
okay. No worries. I wasn't sure if someone was asking a question. Okay. Let's see. Okay, be flexible. Nothing is final until it's final. So again, you just gotta expect the unexpected and be flexible. And as I said before, work with the probate attorney. After closing, encourage proper estate planning. You've got to help clients avoid probate. And really a very common way is using a trust. Right? That's why people talk about trust, living trust, revocable trust, family trust, and so forth. Because a properly drafted, properly funded trust can completely avoid the probate process. All this stuff I just talked about can be completely avoidable. Okay, and this I think is where us advising clients, we can really do a lot of good for families. After your clients have closed on one of the biggest investments of their life, encourage them to do proper estate planning to protect it from all that I just talked about. A lot of people know that they need to do something like this, but they don't know where to start. They don't know what to do. So when you can help them and guide them and provide a resource for it, you become even more valuable of a resource to them as well. So
yeah, it's this question arises more so than anything, right? And it's kind of funny because the advice that I could give somebody would be this. If you are a son or a daughter, which all of you are, and your parents are still alive, and you know that when they pass, that property is going to be left to you, the best Christmas gift, the best birthday gift, the best any gift you could give them is making sure that they have a trust drawn up, right? I mean, your average trust ranges from $2,000 to $5,000, but you saw from this presentation that an average property of, or I won't say property, an average estate of $500,000 of value is going to be a minimal probate of about $26,000. Now, who's going to pay that? Really, the son and daughter are going to pay it because it's coming out of what they potentially will inherit. Now, I've seen probates, and I'm sure the lawyers and stuff have seen them more so than I have, but I've seen probates where things go through probate and it doesn't get left to who they think it's going to get left to, right? The clause come out when the courts are involved, and a lot of times siblings don't see eye to eye or things like that, and it can be an ugly, drug out process. And it's a lot easier to let mom and dad, aunt and uncle, whoever it is, make their own decisions while they're still with us, put that into a trust, and the trust dictates. And then there's no arguing, there's no negotiating, there's no court involvement, and their wishes are fulfilled. Right. It'll be the best gift you can give somebody, right? So if they can't afford it, and that's the reason why they're not doing it, I would say is by all means, find a way to help them get it done, because it's going to save you in the long run. If you are the one that's going to inherit it, all that money is coming out of that.
And those probate fees, that's when nobody's fighting. It's even worse when there's disagreements and families fighting about it.
Yeah.
That's where it gets just exponentially, those fees are exponential. It's very awful to see what happens to families when that occurs.
Yeah.
So the way a trust varies from a will. So a will in its most common sense basically says, here's my stuff and here's who I want to get my stuff after I pass. And here's my executor, the person I want to be in charge of everything after I passed away. Okay, but wills go through that probate process.
Mm-hmm.
Wills contain instructions to a judge who is in court. Okay, we don't, a simple will, any kind of will, just will not avoid probate if any real property is involved or assets are above $166,250,000. Okay, but a trust, on the other hand, basically says, here's my stuff, and here's who I want to get my stuff after I pass. And here's my trustee, kind of like the executor, who I want in charge of everything. It also says, this is what to do if I'm incapacitated. Here's, how to operate my property, and gives much more thorough instructions during lifetime as well. Properly drafted, properly funded trust will completely avoid the probate process. Some of the different roles in a trust include, the first role is the trust maker. Sometimes it's called a trustor, a grantor, a settlor. I like the term trust maker because it's very descriptive to me. It's the person who creates the trust. That's their job, okay, to make the trust maker. The second job is the job of the trustee. That's who's in charge of managing the trust, signing for the trust. They open up bank accounts, they make deposits, writes checks, buys and sells real property. Anything that really needs a signature, that's the job of the trustee. The third job is the job of the beneficiary. Now, their job is to enjoy the benefit of the trust. They get to live in the house and enjoy the money in the bank account. During someone's lifetime, they are all three. Typically, they still enjoy their property. No one else is involved. No one's telling them how to, spend their money. They don't lose any control. They still control all of their money. They control their investments. They can sell the property. They can buy another one, whatever they want. Okay, that's why it's so great and flexible, because they don't lose any of their powers. They don't lose anything when they set this up for themselves and their family. Only after they pass away does someone else step in as the beneficiary, right? Only if they become incapacitated or they're ill or they've passed away does someone else step in as trustee, okay? And the distributions to the beneficiaries are according to their wishes. I have 4 little ones at home. I have 4 little kids, right? I don't have a trust that says, oh yeah, give them money when they're 18. Heck no. What would that look like? Any sum of money in the hands of an 18-year-old is going to be shiny, red, and fast, right? And that's not something I want for my family. So I have a trustee who will still manage it for them until they're older and more mature and able to handle their money. Right? If there's special needs beneficiaries, it's so important that they have a special needs trust, because with special needs beneficiaries, we cannot mess up their benefits. It's very important to keep that in place and intact for them, to not mess up any government benefits that they're receiving. Also, you don't want to disinherit your special needs beneficiary. That's not the way to do it. Please don't do it. It will typically result in them not having the care that they need after you're gone or your clients are gone. The way to protect their benefits and have funds available to supplement the government benefits that they're receiving is by using a special needs trust, right? And as I said, a properly drafted, properly funded trust can completely avoid probate. So what do I mean by that? Properly funded. A trust can only control trust property. So think of all the stuff that people have, their house, their bank account, their car, their stuff. We have to bring this under the control of the trustee. With the bank, it really means when you're at the bank, your bank statement will now say, Fred as trustee of Fred's trust. That's how that bank account is under the control of the trust. Same for the house. When we're funding the trust, there needs to be a trust transfer deed, and it needs to be recorded. And it will say, Dan Smith and Jane Smith, husband and wife, grants to Dan Smith and Jane Smith, trustees of the Smith Family Trust. This must happen, and it must be recorded, or the house was not funded into the trust. Okay. And what happens when we don't fund the trust? We need a probate court. We're off to probate court. I've spent nearly 15 years in court at the DA's office and now in probate court. Nothing good happens in court.
No.
Does someone have a question?
Since we're at this portion, maybe you can explain to everybody what a pour over will is.
Yeah, a pour over will basically says anything I have that's not already in the trust, we're going to pour it into the trust. But it's a will. Wills go through probate.
Correct.
Wills do not avoid probate.
Correct. But if somebody had a pour over will that said, for instance, and this plays a big part because people forget to update their trust. Let's say they go get they invest in a mutual fund, or they go get a bank account that has a substantial amount of cash in it. They buy a property and unexpectedly pass away before they can move it into the trust, right? What's the advantages of having a pour over will versus not having a pour over will? Now, mind you, most pour over wills are developed when the trust is developed at the same time. And it's kind of like a catch net just in case, right?
Right.
Now,
yeah.
The advantage of having one versus not having one, right?
Yeah, I mean, you definitely should have one. In fact, I would say it's, near malpractice not to do one at the same time. So when you have a trust, you should absolutely have a pour over will that pours into it. You can't have a pour over will without a trust. What I have seen, I've actually heard
Correct.
Other attorneys say, oh, you don't need to actually fund your trust, just rely on the pour over will, which is it's just wrong. Completely, it does not avoid court. And our courts here are getting a little bit more strict about it. In making, basically, there's a procedure, it's called a Hegstead procedure, a petition, right, where we can kind of sort of easily get assets outside of the trust into the trust. We've been getting a lot of questions back from the court saying, hey, the pour over will is just not enough. Right. So there has to be more that supports the fact that those were trust assets. I'm not going to go into the nuances of it. So
I bring it up for the reason that there's a lot of people out there in their mind that go, oh, I can't afford $3,000 or $4,000 to have a trust drawn up. So I'm going to use an online service to do it. And what they don't realize is, and I've seen this hundreds of times, where somebody went online and used, one of these online lawyer things to develop a trust themselves. What they don't realize is the verbiage within a trust is very unique to the individual situation. Mm-hmm. And when you use these online services to do it, it is very uniformal across the board. It's not really designed for you. It's designed for everyone. And they use general terminology. And I've seen it numerous times where they thought they were covered and they weren't. And, they thought, oh yeah, I did do a pour over will, but the way that it was written and the way that it read didn't protect them on certain things. And next thing you know, they're in probate anyway. And for what? To save, $1,500, and ultimately it cost them tens of thousands of dollars in the long run.
Right. Yeah, no, absolutely. It's, I had a situation, it was three brothers, mom had three sons, and she got one of the online wills that said, leave everything to my oldest son to take care of his younger brothers. What does take care of his younger brothers mean? All these men were in their 50s.
Yeah.
the judge didn't know either, and she stopped reading after her two oldest son. And oldest son got 100% of everything, and the two younger sons got absolutely nothing. And in that will, she had planned for her potted plants and who would take care of those when she was gone. But it allowed her to mess up and disinherit two of her sons. So yeah, you're absolutely right.
There was a question in the chat as well. It
Okay.
said, do you recommend using a trust company as the successor trustee?
Yeah, that's a great question. It really depends on the situation. I mean, there's no easy answer to that. Sometimes family can be fine. Other times family is not a great solution. And there are trust companies, there's private fiduciaries, there's other options. So that's one of the things we work through with the families that we serve and ask them that. We go through what they want to see done. Does it work in their family? It really is it's a very specific question. It's just, there's times, yeah, absolutely, I recommend using a trust company. Other times, it's really not needed. So it varies depending on the situation, the family situation.
I think a lot of it, I get the question a lot too, very similar to this. And my response is usually always, the family should communicate to one another, right?
Yeah.
In some cases, the parents don't want to involve the kids of how they're going to leave things because they don't want to have the debate or argument now. They'd rather just be like, hey, I'm gone and here's what it's going to be.
Right.
In that case, you probably may want a third party that's going to manage that. If you're not in a situation where you can have an open conversation, right?
Right.
And in some cases, you have 2 or 3 siblings and the parents have a conversation and says, hey, we did up a trust and one of you have to, be in charge of it in our absence. And
Right.
a lot of times the 3 siblings can see eye to eye and say, Fred should do it, right? Or Susie should do it. And, it's just a no-brainer. And really what they need to understand is you're not making decisions just because you're in charge of the trust. We've already dictated what's going to happen with everything. You're just the one that has the ability to fulfill those wishes.
Right.
And if they understand that, it should solve a lot of the debating and the back and forth. But sometimes you have 2 siblings that are both alpha and they are like, no, I should be in charge. The other's like, I should be in charge. Well, more than likely, probably neither of them should be in charge.
Right. Yep.
So it really comes down to communication. But yeah, in some situations, if there's only, say, 1 or 2 children and they probably did not live the, so to speak, proper lifestyle, and the parents are looking at it going, I'm not certain they're capable,
Right.
then maybe a trust company to be the successor trustee is probably in order, right?
Absolutely.
Every situation is going to be different.
And it is. Every situation is different. And that's why it's important to have these conversations. That's, part of the conversation is to sit down and have with an attorney to talk about it.
Mm-hmm.
Reveal the concerns that the family might have, reveal the family dynamics and see what would be the best solution for that family to avoid the problems, because nobody wants to see their family implode or set them up to implode later on.
Right.
I have a question.
Yeah, please.
Okay. I have a unique situation to where a possible listing up in LA. It's going through probate right now. Problem is there are squatters in the property. And I can't find an attorney or anybody that's willing to take it on right now due to the moratorium that's in place. Meanwhile, the trustee is accruing some debt on the property. Actually, the property is accruing debt on that. Any recommendations on how to move forward until the moratorium's out of place?
Where's the property listed at? Or at?
LA County.
It's in El Monte.
El Monte.
Yeah, El Monte in LA.
I'd be willing to look at it if you want. I've had that situation happen and we deal with it. So I'd be willing to chat with you more about it and chat with the clients about it.
Okay, terrific. Thank you.
I'll give you my contact information in just a second.
Okay.
And I see another question: how often should a trust be reviewed? Anytime that there's a significant life situation, if there's a birth, a death, a marriage, a divorce, and then every 2 to 3 years. And when you say reviewed, I believe you should take it off the shelf, read it. The last thing you need is be like, oh my gosh, my old college roommate's still listed as my successor trustee. Don't let that happen. Make sure it still reflects your wishes. And then, depending on if there are changes in the law, then have an attorney review it and take a look at it. If it's been several years before since you've had it done or reviewed with an attorney, now's probably a good time to have an attorney review it. But I always say, significant life changes, life, death, marriage, divorce, and then every 2 and 3 years, make sure you read it and it reflects your wishes.
What about, let's say, my trust was done 15 months ago and I decided to buy another investment property. And yes, during the process, I had it moved into my trust, meaning deeded into my trust.
Yep.
But I haven't really updated my trust with my wishes of what's going to happen with that property, right?
Well, then depending on what you want to see done. So
Right.
If there are specific wishes for that specific property, absolutely, you need to talk with the attorney to make sure that gets updated. Please don't start writing in there and handwriting it. Again, don't save a few $100s. That's going to cost tens of thousands of dollars on the flip side. Have it done right. Go back to the attorney that you worked with, tell them what the wishes that you have for that property, and make sure that they can get it done for you.
All right. Any other questions from any of the viewers? I don't see anything in the current chat. So, Andrea?
All right. I know we're getting to the 1 hour mark, so I've skipped a lot of stuff here. So I'm just going to skip to, let's see. Am I sharing?
Yep.
Yep.
Okay. An invitation to join our advisor network. With this, you'll be the first to know of updates in the law. You'll also receive resources for building your business. You have VIP access to our network through several events that we have through the year. You'll receive exclusive trainings as well as access to trainings for your clients. Many times agents have asked us to present on estate planning. I just touched on a little bit just because there's so much to cover today. But they wanted us to present on estate planning to their clients. We're able to do that and then brand that for you, so you can use that as a way to provide extra value to your clients and their friends. You ask them to invite their friends, especially if they have a friend who's been talking about selling their house or buying a house. So that's a good way for you to make new friends with your clients' friends. I also wanted to invite everybody to an individual probate training and strategy session. It's an opportunity to get personalized training, to discuss these concerns with your clients, as well as a strategy to protect your family, as well as a strategy to protect your business. So the way it works, it's a 45-minute meeting, either in our office or via Zoom, where we will discuss what your concerns are. We'll also train you to discuss probate avoidance topics with your clients, discuss whatever your concerns and goals are, develop a strategy to protect your family and your business, and answer whatever questions that you'll have. The total value is generally $750, but we, thanks to Tommy and Mary Jane, we are offering that to you free of charge. So they've arranged for us to be able to offer that to you free of charge. The only thing is you've got to send me a chat message to Andrea Shoup with your name, phone number, and email, so that my assistant can reach out to you. So there's, what's the catch? There is no catch. I just have limited space. So I've got to know today if you want to take advantage of this offer. There's, there's no hidden cost or fees to it. It really is, we're providing it for you. All you've got to do is send a message to me, Andrea Shoup, with your phone number and email address so that my assistant can reach out to you. So, and as a gift for you, then we're going to be sending you the top mistakes to avoid when talking about your estate plan. So it's an individual probate training and strategy session. Or if you want, you can call in with that information. And with that, I am going to be done. I did cut off quite a bit of my presentation on estate planning specifically and some of the pitfalls that I see happen and stuff to avoid. So Tommy, if you'd like, I'm happy to come back again in a few weeks, few months, whatever you'd like, but I did cut out quite a bit. So with
Perfect.
that, I am done. 1 hour.
Wow, that was
Well, I mean, our
awesome.
whole goal today was really around probate and things like that. So I think we covered all of that. I'm assuming that we answered most questions that people and concerns that people had in regards to probate. Guys, I mean, moral of the story is avoid probate at all costs, right? The best advice you can give your clients when they buy a house is they should probably establish a trust. You know, if people think, well, I'm young, I'm a first-time home buyer, oh, I don't have kids yet. Well, great. What happens if you pass away and you own this house? I mean, it's still, you're going to just leave it to the state? Are you going to make your family pay to try and figure out how they're going to be able to take possession of it? You know, maybe it's a brother or sister that is alive or what have you. It's just the best advice you can give somebody is educating them on the importance of how to avoid probate.
Absolutely. Yeah, I agree. I appreciate the opportunity to chat with everybody. If anybody has any other questions, let me know. Or if you really, you're welcome to reach out. I mean, take advantage of the offer, you know, book a strategy session with us. There's no cost. So we don't offer many of those anymore, but I do it for Tommy and Mary Jane. So
You're the best. We appreciate it. And yeah, I've got a few people that I want to connect you with as well, Andrea.
oh, great. Thank you, Tracy. I appreciate that.
Absolutely. Awesome. Okay, everybody. Well, have a great day. Appreciate it.
All right, guys.
Cheers.
Well, hey, we thank you for joining us again. We do these Zoom and Learns to add value to you so you can add value to your clients. So by all means, please join us every Monday. We go live at 12:30. It's a different topic. We try and keep it as relevant to today's market as possible. And with that said, we look forward to seeing you next Monday. Same Zoom link, same time. And Andrea, thank you so much for taking the time out of your day to drop some knowledge on probate to us. It's greatly appreciated as always.
Absolutely. Thank you. We'll see you later. Hi, Andy.
Thank you, guys.